Hello.
Yes, good afternoon, all. Yeah. Uh, Today I'm going to discuss about other two blocks of your course, that is protection of other industrial property and operational aspects of protecting intellectual property in India. So here, one of the important legislation passed by the Indian Parliament to extend the protection to the geographical property, that is what we call as a geographical indications, that is another sort of industrial property protected under the both the national and international legal regime. Then what do you mean by geographical indication? uh, Geographical indication in a simple terms, GI, it is a status accorded to a good which is unique to a particular region or area and are originated from there. So usually these goods have a reputation for their quality. They are associated with a sense of legitimacy and trust simply because they have the tag of belonging to that region. That means GI, popularly known as geographical indications, an indication used to identify a certain class of goods originating from a definite territory in India. That is, it may be identify the agricultural goods, natural goods, or manufactured goods by tagging that GI, we are identifying those goods. So here, it should have a special quality, a characteristic or reputation based upon the climatic or production characteristic unique to the geographical location. So, because certain goods manufactured in a particular geographical regions, it is attached with a special quality or a characteristic or reputation. So that's what we are recognizing them as a geographically indicated goods, GI tagged goods. For example, basmati rice. Basmati rice is known for its unique aroma and long grains. It is unique to the Indo-Gangetic plains. 7 states of India, after a long battle, legal battle, have been accorded with the status of geographical indications in the year of 2016 for the basmati rice. Likewise, Darjeeling tea. So it is another a product in our country which is having a GI tag. Kanchipuram silk saree, Alfonso mango, Nagpur orange, Kolhapuri chapels, like many more geographically indicated goods are protected under the present legal regime. Here, certain goods are covered under the ambit of geographical indications. One is first category of the goods covered under the geographical indication protections. One is agricultural goods. For example, basmati rice. It is comes under the category of agricultural goods, which used to get a GI tag. It depends upon the special quality or a characteristic attached to that goods. Another category, that is natural goods, naturally available goods. It used to get a GI tag. So, example, Makrana marble, especially it is, originated from the one of the place of Rajasthan. Naturally available Makrana marble used to get a GI tag. Another category of goods covered under the ambit of GI, that is handicraft or any industry, handicraft or any industry. So, like example, Kashmiri Pashmina. So here are in Karnataka the Chanpatna toys. So these are the handicrafted goods used to get a GI tax. Then apart from these three categories, there is a one more category comes under the ambit of GA, that is a food stuff. Food stuff. For example, Dharwad Peta in Karnataka. So you used to get a GI tag. So these are the four categories of goods are covered under the ambit of geographical indications in India. One is agricultural, natural, handicraft or any industrial product, food stuff. So these are mentioned under these are the category mentioned under the present act of GI Act under Section 2G of the Act. So GI it is a collective intellectual property right. It is not an individual property right, not like a patent or a copyright or some other intellectual property. It is a collective intellectual property rights given to the a group of producers or farmers like that. So here, GI is a collective intellectual property, that is any association of a person, producers, organization established by or under the law can apply representing and protecting the interest of the producers. So, extending a production to the goods by granting a GI tag, it is protecting the interest of the group of people. Group of people, that is a group of persons. If it is an association or organization established under the a given law of the land. So that is the a geographical indication. It is and nothing but a tag given to a particular goods, sorry, particular goods in order to extend the production. So here, apart from the yes, so sorry, yeah. So here there are many legal aspects of when we talk about the legal aspect of geographical indications. A laws relating to geographical indications, it were introduced in India after the ratification of the trade related aspects of intellectual property agreement, that is a TRIPS agreement, where India was signed the TRIPS agreement. The TRIPS agreement was signed by all the WTO members country as a single undertaking. A single undertaking for WTO is basically an agreement signed by all the member nations. Here, a TRIPS agreement set a minimum standard of protection for the goods registered under as a geographical indication, because at the international level, WTO, World Trade Organization, which establishes the TRIPS agreement, that TRIPS agreement sets a minimum standard of protection for the goods. So accordingly, Indian Parliament, in the line of the TRIPS agreement, come out with the one a comprehensive legislation called Geographical Indication of Goods Registration and Protection Act 1999. In the year of 1999, so the parliament come out with the legislation in order to extend the protection to the geographically originated goods, because here, so India as a member of the World Trade Organization enacted the geographical indication of the goods, so which came into force in the year of 2003. This act is a comprehensive legislation which provides a provision relating to the registration, protection, granting of rights, and provision for the filing a petition against the infringer and remedies available. So these are the remedies provided, comprehensive procedure provided under the GI Act, Geographically Indication Act. So here, how to protect the geographical indication in India? How to get registration of the good as a GI? Then who can apply for the registration of a good as a GI? Here, any association of person. Already, I told you earlier, it is a right given to a group of individual, not to an individual. Here, who can make a application for registration of the GI? Any association of persons, producers, organization, or authority established by or under the law can apply. The applicant must represent the interest of the producers, because on behalf of the group of producers, an individual is going to file a petition, application before the competent authority to register the good as a GI tagged goods. So how to register a good as a GI? Here there are different types of application. One is ordinary, for registration of a GI in India, ordinary application. Then conventional application. That is registration of the GA, which is already recognized in another country that is called as a conventional application. Then single clause includes a registration of a goods belonging to a particular class of goods, because already I told you the four class of goods. Single class of goods includes the registration of a GA belonging to the particular class of goods. Then multi class includes registration of goods belonging to the multiple classes of goods. So at the same time, where you are going to get registration of a multiple class of goods under the single application. So these are the four types of applications available to get registration of the goods as a GI tag. Then the registration process for the GI tag begins with filing of an application for the same. Geographical indication registry is there. Under the Act, we have established the geographical indication registry. So that registry always demands application must be made in triplicate. Application must be made in triplicate. The applicants may be the producer or producers of the respective goods themselves, or any organizations or authority which have the permission to act as a agent of the producers. The application must be filed to the office of the GI registry, which is in Chennai, which is situated in Chennai. The application must contain all the relevant details, like the details of the principal place of business. So, principal place of business has to be mentioned in the application, defined under the section 3 of the geographical indications of goods registration rules 2002. Then that application must contain the historical evidence to back the claims. Historical evidence to back the claims. So mere submission of application, it is not suffice to get a registration of the GI. There must be a sufficient historical evidence to claim the rights about that product. Then a detailed description of the good and its usage. A detailed description of the good and its usage. Then a method of production, other relevant details for determining the GI status of the goods. Because these are the very much, I mean, these are the points very much required to get registration along with the application. The applicant must provide a detailed description of the goods and its utility. Of course, they have to provide the method of productions, then relevant details for determining the GI status of the goods. Then after the submission of the application will be subjected to scrutiny by the registry and a panel of experts, which would be designated by them. The applicant will have the time of 1 month to remedy the errors, if any. Then the applicant, sorry, registrar is further vested with the powers to rescind the application if the errors are not dealt with. Upon the acceptance of the application, the registry will publish the same within 3 months of the acceptance. Any person can file an opposition to the publication of the GI application within 3 months. So it can be extended, provided for another 1 month. After the acceptance of the application, the date of filing of the application will be the date of registration. Date of filing the application will be the date of registration. A certificate with the seal of the GI registry shall be issued to the applicant. Then, so any person may and prefer an appeal against the registration. It can be made to the Intellectual Property Appellate Board earlier, now before the High Courts within 3 months of the registration of the goods. If anybody wants to challenge the grant of GI tag to any goods, then they may prefer an appeal to the High Court challenging the grant of GI. So, on acceptance of the application, the registrar shall register the geographical indication for the same, because there is a register maintained by the registry. So in that register, they have to mention the and the goods granted a GI tag has to be mentioned in the register. If registered the data if registered, the date of filing of the application shall be deemed to be the date of registration. Yes, the registrar shall then issue to the applicant a certificate with a seal of geographical indication registry in a form prescribed under the rule. Then, what is the duration once it is granted or registered? The goods under the GI Act, a registered GI shall be valid for 10 years and it can be renewed on payment of renewal fees. So once it is registered, it will be protected up to 10 years. So beyond 10 years, if the registered GI holder wants to get protection, then they have to renew the same on payment of renewal fee. The application must be made addressed to the geographical indication registry, Chennai, and thereby used to get a renewal. At the time, where if it is if there is any failure on part of the parties or GI holder to get renewal, then within stipulated time there is a lapse of GI tag registration. So that's what here the Act created, Section 18 of the Act created. Failure to do so may result in removal of the geographical indication. Where the geographical indication has been removed by the registrar on grounds of non-payment of the renewal fees, may after 6 months and within period of 1 year from the expiration of the last registration of the geographical indication, may on an application in a prescribed manner and after the payment of prescribed fee may restore the geographical indication for a period of 10 years from the expiration of the last registration. Because if there is a failure on part of the parties to renewal the GI, then so after 6 months of the lapse of time and within 1 year from the expiration of the last registration, so you may apply for the restoration of the GI. Then a registered geographical indication prohibits a third party to use such geographical indication by any means in the designations or presentations of goods, indicating that such goods originate in a geographical area. So that means there is a clear-cut prohibition on part of the parties or a third party. So misrepresenting such goods, saying that is a GI goods, that is prohibited under the Act, prohibited under the Act of 1999. GI registration, it provides a legal protection to the goods in national and international markets. It promotes exports and provides a financial benefits because once the product comes under the GI legal regime, definitely so it promotes exports and provides a financial benefits, and also it creates a larger number of employment in the system, and also it prevents unauthorized use of the GI and gives the right to sue for infringement, because once it is legally recognized under the Act, definitely if anybody misrepresenting that goods, that then the aggrieved person may bring an action against such person, such unauthorized person under the Act. Here, certain goods are prohibited on registration of geographical indications. Section 9 of the Act provides that which cannot be registered under the GA registry. One is where such goods may cause confusion or deceive the public, because there must be certainty with regard to a quality or reputation of the goods. So if such GA tags, such goods are causing any confusion or a deceive, definitely so it is not subject to the registration of GA indications. And where the goods which may be scandalous in nature, it is prohibited. Then where goods are contrary to the laws in force at the time, definitely it is not subject to registration. Then whereas goods may hurt religious sensibility, so definitely it is a prohibited. Where goods are generic, that is not unique, it is not subject to registration. Then what about the transfer of GI and GI? So here, Section 24 of the GI Act state that GI tag cannot be transferred to any other user under any condition. Only in case of the death of the authorized user, the rights of the GI shall devolve on his successor in title under the law for the time being in force. That means So not like a patent or a copyright, it is not a transferable. It is not transferable. So because it is a community rights, it's an association used to get a rights, and not an individual producer. It used to get a GI tag. It is a group of producers, a group of individuals used to get a rights, because GI is a public rights available to a group of member. So that's what it is a prohibited to transfer under section 24 of the act. Only upon the death of a authorized user, then the rights of such holder shall devolve on his successor entitled under the law for the time being in force. Renewal we have already discussed. Then what is the provision for the infringement of the geographical indications? Section 24 of the Act state that laws relating to infringement of geographical indication, and this section has to be read with the section 2 of the Article 22 of the trade related aspects of intellectual property rights, which says in respect of geographical indication, members should provide a legal protection to interested parties to prevent use of any means in the designation or presentation of good that indicates or suggests that good in question originate in a geographical area other than the true place of origin, which confuse the public. That is where a goods used to get a geographical status that should not be misrepresented by the or mispresentation by the uh, other persons. So definitely it amounts to infringement of the GI indication. Then any any use which includes an act of unfair competitions within the meaning of Article 10 of the Paris Convention, that amounts to infringement of the geographical indication. Is there any remedy available for the enforcement of the geographical indications? Of course, Section 67 of the GA Act 1999 provides both remedies like civil remedies and criminal law remedies. Civil law remedies, there is injunction, damages or account of profits. One can seek a delivery of infringing labels and indications for the destruction or even forfeiture of the goods that bore false representation of existing GI. Then criminal law remedies also available. Punishment, that is imprisonment 6 months to 3 years plus fine not less than 5,000, sorry 50,000, but may extend to 2 lakh. So these are the remedy available to the uh, infringement of the geographical indications. Friends, the potential of the GI has not yet been realized in India, as the efforts have so far mainly focused only on the first step of filing the GI. Because filing a GI application is a used task that involves a documenting historical evidence about the linkage of the product with the region, and the application has to be filed by an association or a group of persons. So that is the a cumbersome process involved in the registration of the GI, because here the applicant must navigate the goods with that of historical background, historical evidence. That is a very tedious task to collect the historical evidence. So that is the one uh, issue. Another one, the recently the Indian Ministry for Commerce and Industry unveiled a tricolor logo that is common for all geographical indications with an impressive tagline, invaluable treasures of incredible India. So here, India is a land of natural resources. That's what you are amazed to know that India is a massive or a huge fame in the international platform with more than 400 GI tags, 400 GI tag. The two Karnataka has the highest number of GI tags, that is 47 products, followed by Tamil Nadu. Some of the major products that have got GI tag are Mysore silk. So mentioning Mysore silk is one of the a famous fabric produced in the local, that is a Mysore and inner around Mysore, that is a Mysore silk of India, sorry Karnataka. These are the things about the geographical indications, which is extending a protection under the legal regime to the goods originated in a particular area or a particular place where that place provides to such goods a special quality or reputations to such goods, then that such goods are protected. Friends, let us move on to the another enactment, another area of intellectual property rights, that is biodiversity and the Indian law. Friends, here biodiversity, that is Biological Diversity Act 2002. It was born out of India's attempt to realize the objectives enshrined in the United Nations Conservation and Biological Diversity 1992, uh, which recognizes the sovereign rights of the states to use their resources. Biological resources. Friends, what do you mean by biodiversity? The biodiversity means the variability among living organisms from all sources and the ecological complexes of which they are part and includes diversity within the species or between the species and of ecosystem. Another one, biological resources, biodiversity and biological resources. Biological resources here means plants, animals, and microorganisms are a parts thereof. Their genetic material and byproducts, excluding the value-added products, within the actual or a potential use or a value, but does not include human genetic material. So here the act was enacted by the Parliament in the year of 2002 with the aim of conservation of biological resources, managing its sustainability, use, and enabling fair and equitable sharing benefits arising out of the use and knowledge of biological resources with the local community. The very objectives or features of act which prohibits the certain activities without the prior approval of the National Biodiversity Authority, which is a statutory authority created under the Act of 2002. Any person or organization, either based in India or not, obtaining any biological resources occurring in India for its research or commercial utilization, they are not supposed to uh, approve or make use without the consent of or approval of the National Biodiversity Authority. The transfer of the results of any research relating to any biological resource occurring in or obtained from India, so they have to go through the National Biodiversity Authority. Then the claims of any intellectual property rights on any invention based on the research made on the biological resources obtained from India should be approved by the National Biodiversity Authority. So, because the natural resources are protected under the Act of, biological resources are protected under the Act of 2002 by establishing the National Biodiversity Authority under the statute. Here, the Act envisaged a three-tier structure to regulate the access to biological resources. One is by establishing the national level biodiversity authority, then state level biodiversity boards, then biodiversity management committees at a local level. Here, the Act provides these authorities with a special funds and a special budget in order to carry out any research project dealing with the biological natural resources of the country. So here the Act shall supervise any use of biological resources and the sustainable use of them, and shall take control over the financial investments and their return and dispose of those capitals as a correct. Under the Biological Diversity Act, the central government, in consultation with the National Biodiversity Authority, shall notify threatened species and prohibit or regulate their collection, rehabilitation, and conservation, designate institutions as a repositories for different categories of biological resources. Because it is very much required to protect the species uh, from threaten and prohibits and regulate their collections and rehabilitations and conservation by the people at large. So here the Act stipulates all offences under it is as cognizable and non-bailable offence. So this Act has created certain exemption. One is Act excludes the Indian biological resources that are normally traded as a commodities. The Act exclude Indian biological resources that are normally treated as a commodity. Such exemption holds only so far as biological resources. Biological resources are used as a commodities and for no other purpose. So that is the one thing created. Then the Act also exclude the traditional uses of Indian biological resources and associated knowledge, and when they are used in a collaborative research projects between India and foreign institutions with the approval of the central government, uses by cultivators and breeders. Example, farmers, livestock keepers, and beekeepers and traditional healers. Example, Vaids and Hakims are also exempted from the application of the Act 19, sorry, 20, 2002 Act. Then, as I discussed, the Biodiversity Act 2002 provides a provision to establish the National Biodiversity Authority. Which was established in the year of 2003 by the central government to implement the India's Biodiversity Act. It is a statutory body that performs a facilitative, regulatory, and advisory functions of the government of India on the issue of conservation and sustainable use of biological resources. Because the main motto behind the enactment of the Biological Diversity Act 2002 to conserve and conservation and sustainable use of the biological resources. Here, the NBA has its headquarters in Chennai, Tamil Nadu. When we see the structure of the National Biodiversity Authority, it consisting of certain members to be appointed by the central government. One is a chairperson, three ex officio members, one representing the ministry dealing with the tribal affairs, and two representing the ministry dealing with the environment and forest. Then seven ex officio members to represent respectively the ministers of the central government dealing with the agriculture, research and education, biotechnology, ocean development, agricultural, sorry, agriculture and the cooperation, Indian system of medicine and homeopathy, science and technology, scientific and industrial research. Five non-official members to be appointed from amongst specialists and scientists having special knowledge and experience in the required matter. What are the functions of this National Biodiversity Authority? One of the function is that creating an enabling environment as appropriate to promote conservation and sustainable use of biodiversity. That is one of the main function. Then advising the central government, regulating the activities and issuing guidelines for for access to biological resources and for fair and equitable benefit sharing in accordance with the Biological Diversity Act. Then advising the state government in the selection of areas of biodiversity importance to be notified as a heritage sites and suggest measures for their management, then taking a necessary measures to oppose the grant of intellectual property rights in any country outside India on any biological resources obtained from India or knowledge associated with such biological resources derived from India illegally. So apart from National Biodiversity Authority, there is an establishment of the State Biodiversity Board. Here, the State Biodiversity Board are established by the state government in accordance with the Section 22 of the Biological Diversity Act 2022. Here, what is the structure of the State Biodiversity Board? That is, there is a chairman and not more than five ex officio members to represent the concern. Then departments of the state government, concerned department of the state government, not more than five members from among experts in matter relating to the conservation of biological diversity. sustainable use of biological resources, and equitable sharing of benefit arising out of the use of biological resources. Then all the members of the state biological board are appointed by the respective state government. Respective state government. Then it used to have a certain functions. One is advise the state government subject to any guidelines issued by the central government on matters relating to the conservation, sustainability use of the use or sharing of equitable benefits. Another function of the SBB, State Biodiversity Board, regulate by granting approvals or otherwise request for commercial utilization or biosurvey and bioutilization of any biological resources by the people. Then one more tertiary level authorities created, that is a biodiversity management committees at the local level. According to Section 41 of the Biological Diversity Act, every local body shall constitute the Biodiversity Management Committee within its area for the purpose of promoting conservation, sustainable use, and documentation of biological diversity, including preservation of habitats, conservation of land races, folk varieties and cultivars, domesticated stocks and breeds of animals, microorganisms, and chronicling of knowledge relating to biological diversity. Then, when we see the structure of the BMC, it shall consisting of a chairperson and not more than six members nominated by the local body. Out of total members of the BMC, not less than one third should be women and not less than 15 should belongs to the scheduled caste and scheduled tribes. The chairperson of the Biodiversity Management Committee shall be elected from amongst the members of the committee in meeting to be chaired by the chairperson of the local body. The chairperson of the local body shall have casting votes in the case of tie. And when we see the functions of this local committee, the main function is that to prepare a people's biodiversity register in consultation with the local people. Register shall contain comprehensive information on availability and knowledge of local biological resources, their medicinal or any other usage of usage or any other usages. So this is about the Biological Diversity Act to extend the protection to the biological resources. Let us move on to the another area, that is protection of plant varieties and the Farmers' Rights Act 2001. Protection of Plant Varieties and Farmers' Rights Act 2001. Friends, this is the enactment made by the Parliament in the year of 2001 in order to protect the plant varieties and protect the farmers' rights, breeders' rights, and the farmers' rights. With the very objective of it is that to establish an effective system for the protection of plant varieties, the rights of the farmers and plant breeders, and to encourage the development of new varieties of plants, to recognize and protect the rights of farmers in respect of their contribution made at any time in conserving, improving, and making available plant genetic resources for the development of a new plant varieties. That is another objective behind the act. Then one more purpose is that to accelerate agricultural development in the country, protect a plant breeders' rights, stimulate a investment for research and development, both in public and private sector, for the development of a new plant varieties. Then another objective behind the act facilitate the growth of seed industry in the country, which will ensure the availability of high quality goods, I mean high quality seeds and planting material to the farmer. These are the four main objectives behind the Plant Varieties and Farmers' Right Act 2001. This act set up to promote a new varieties of plants and protecting the same along with the rights of the farmers and breeders. That is the main motto behind the legislation. That is to promote new varieties of plants and protecting the same along with the rights of the breeders or farmers. Then how to register the plant varieties. So registration of varieties, what are the criteria for protection under the legislation? A new plant variety shall be protected by registration if it is novel, it must be new, and it must have a distinctive character, and it must be uniform and stable. There is no any instability or uncertainty. There is no any irregularity. So if you want to register any variety as a plant variety under the act, it must be qualified a novel one. It is a new one, not known to the not known to the people earlier. It must be distinct, uniform, and sustainable. That is, a variety is eligible for registration under the Act if it is essentially fulfill the criteria of distinctiveness, uniformity, and stability. These are the three major criteria to grant protection to the plant varieties. That is distinctiveness, uniformity, and stability. The central government issue a notification in official gazettes specifying the genera and species for the purpose of registration of varieties. So far as the central government has notified 157 crop species for the purpose of registration. So the very rationality behind the enactment to set up to promote a new varieties of plants and protecting the same with the farmers' right and breeders' right. So this act provides a certain rights to the breeders and researchers and farmers. What are the rights available to the breeders under the act? Friends, breeders will have exclusive rights to produce, sell, market, distribute, import, or export the protected variety. Breeder can appoint an agent or license and may exercise for civil remedy in case of infringement of rights. That is, so the breeders will have exclusive right to produce, sell and market, distribute, import or export the protected varieties. It is protected under the Act of 2001. Then researchers' right also available under the Act of 2001. Researcher can also use any of the registered variety under the Act for the conducting experimental or research. This includes use of variety as an initial source of variety for the purpose of developing another variety, but repeated use needs prior permission of the registered breeder. Apart from the breeders' right, researchers' right, here the farmers' rights also extend a protection under the Act 2001. A farmer who has evolved or developed a new variety is entitled for the registration and protection in like manner as a breeder of variety. That is the rights given to the farmer. A farmer's variety can also be registered as an extant variety. Then farmer can save, use, sow, resow, exchange, share, or sell his farm produce, including seed of a variety protected under the uh, Plant Varieties and Farmers' Rights Act 2001 in the same manner as he was entitled before the coming into force of the this act provided farmer shall not be entitled to sell branded seed of variety protected under the PPV and FR Act 2001. Then there is a farmers are eligible for recognition and rewards for conservation of a plant genetic resources of land, races, and wild relatives of economic plants. There is also a provision for compensation to the farmers for non-performance of variety under section 32, 39, subsection 2 of the Act of 2001. The farmer shall not be liable to pay any fee in any proceedings before the authority or registration of the tribunal or the high courts, registrar or the tribunal or the high court under the act. In order to implement the PPV and FR Act 2001, uh, here that to implement the provisions of the Act, the Department of Agriculture, Cooperation and Farmers Welfare Ministry of Agriculture and Farmers Welfare established the Protection of Plant Varieties and Farmers' Right Authority on November 2005. On 11th November 2005, they have established that Protection of Plant Varieties and Farmers' Rights Authority. Protection of Plant Varieties and Farmers' Right Authority. Here, this authority having a chairperson who is the chief executive of the authority. Beside the chairperson, the authority has a 15 members as notified by the government of India. Eight of them are ex officio members representing the various departments, ministry, three from SAUS and state governments, one representative from each from farmers, tribal organizations, seed industry, and women organizations associated with the agricultural activities are nominated by the central government. The Registrar General is the ex officio member of the member secretary of the authority. So, in order to effective implementation of this act, yes, the central government, the Department of Agriculture and Cooperations establishes the farmers will, protection of plant varieties and farmers' rights authority. What are the general functions of this authority? Farmers' Rights Authority, Plant Varieties and Farmers' Rights Authority. Registration of a new plant varieties, essentially derived varieties, extant varieties. So that is a general function of the authority. Another one, developing distinctiveness, uniform and stability test guidelines for new plant species, developing characteristic and documentation of the varieties registered, then compulsory cataloging facilities for all varieties of plants, documentation include indexing and cataloging of farmers varieties, recognizing and rewarding farmers community of farmers, particularly tribal and rural community, engaged in conservation and improvement, preservation of plant genetic resources of economic plants and their wild relatives, maintenance of the National Register of Plant Varieties, and maintenance of the National Gene Bank. So once uh, the plant variety is registered, so how long it is protected under the Act, and is there any infringement of the registered plant varieties, and what is the remedy available? Here for trees and vines, 18 years from the date of registration. It is protected till 18 years. For other crops, 15 years. For other crops, 15 years. For extant varieties, 15 years. This is the term provided. Then infringement of any right under the PV Act attracts both civil and criminal actions. Infringement means producing, selling, importing, exporting any variety without the permission of the owner or using of the denomination which is similar to the act, which is similar to a registered denomination, likely to confuse, likely to confuse. That is the that amounts to infringement. Then, what are the relief available under the Act for a suit for infringement? Here, a relief which a court may grant in any suit for infringement referred to in Section 65 includes an injunction and at the option of the plaintiff either damages or share of profit. So the order of injunction under subsection 1 may include an ex parte injunction or any interlocutory order for any of the following matters, namely discovery of documents, preserving of infringing variety or documents or other evidence which are related to the subject matter of the suit, attachment of such property of the defendant which the court deems necessary to recover damages, cost, and other pecuniary remedies which may be finally awarded to the plaintiff. Once the plant varieties is registered under the Act, a certificate of registration issued will be valid for 9 years in case of trees and vines and 6 years in case of other crops. So it may be reviewed and renewed for the remaining period on payment of renewal fees, subject to the conditions of that the total period of validity shall not exceeding 18 years in case of trees and vines from the date of registration of the variety, 15 years from the date of notification of variety under the Seeds Act 1966, and in other cases, 15 years from the date of registration of the variety. Then, benefit sharing is one of the most important ingredients of the farmers' rights. Section 26 provides that benefit sharing and the claims can be submitted by the citizens of India or firms or a non-governmental organization formed or established in India, depending upon the extent and nature of the use of genetic materials of the uh, climate in the development of variety, along with the commercial utility and demand in the market of the variety. Because variety, breeders will deposit the amount in the gene fund. So the amount deposited will be paid to the claimant from National Gene Fund. The authority also publishes the content of the certificate in the PVJI for the uh, purpose of inviting a claims for benefit sharing. Then it is a community right, as I told you, it is compensation to the village or local communities for their significant contribution in the evolution of variety which has been registered under the Act. Registered under the Act. Any person or a group of persons, governmental or non-governmental organization, on behalf of any village or local community in India, can file in any notified center claim for contribution in the evolution of any varieties. That is the it is about farmers' right and breeders, farmers protection of plant varieties and Farmers' Rights Act 2001. Friends, another area of intellectual property, that is protection of semiconductor integrated circuit layout design. Protection of semiconductor integrated circuit layout design. Semiconductor integrated circuit, it is an integral part of every computer chip. The fifth generation computers are using very large scale integrations where numerous transistors are accommodated on a single chip, cutting down the size of the chip and at the same time increasing its processing power significantly. This ultimately translates into smaller and more powerful computers. Hence, the development of a layout design on a semiconductor integrated circuit as an intellectual property is a quite significant. A step was taken by a various organizations to pass regulations regarding this issue. One such was World Trade Organization, and the result was that TRIPS agreement addressing the intellectual property related issue. India, being a signatory of the World Trade Organization, also passed an act in conformity with the TRIPS agreement called Semiconductor Integrated Circuits Layout Design Act 2000. Semiconductor Integrated Circuit Layout Design Act 2000 passed in the year of 2000. Here, Semiconductor Integrated Circuit Layout Designs Act is a supplement act to designs. Supplement acts to designs. It provides the obligation of TRIPS agreement. It fulfills the obligation of a TRIPS agreement regarding the protection of semiconductor integrated circuit layout designs. Then Act provides a definition to the various terminologies come across in the legislation. One is semiconductor integrated circuit. What do you mean by semiconductor integrated circuit? So usually it's a technicality involving in these terminologies. Semiconductor integrated circuit means a product having transistors or other circuitry elements which are inseparably formed on a semiconductor material or an insulating material or inside the semiconductor material and designed to perform an electronic cir- sorry, electronic circuitry function. Then layout design is also defined under the Act. Layout design means a layout of transistors and other circuitry elements and includes lead wires connecting such elements and expressed in any manner in a semiconductor integrated circuit. Then commercial exploitation. In relation to the semiconductor integrated circuit layout design means to sell, lease, offer, or exhibit for sale or otherwise distribute such semiconductor integrated circuit for any commercial purpose called commercial exploitation. What is protected under the legislation? A layout design expressed in any manner which is original, which has not been commercially exploited for more than 2 years from the date of application or the registration, which is inherently distinctive and capable of being distinguishable from any other registered layout design. It is protected or registered under the Act. So keep in your mind, friends, what is protected means here a layout design expressed in any manner, so there is no any specifications expressed in any manner which is original, which must be original and novel, which has not been commercially exploited for more than 2 years from the date of application for the registration. And it is also inherently distinctive and capable of being distinguishable from any other registered layout design. Definitely, it is protected under the Act or registered under the Act. Then, who can apply for the protection of integrated circuits or layout designs? Protection of layout design. An application for the protection of layout design can be made by the person who claims to be the creator of the layout design or is legal representative, a person registered in the prescribed manner as a layout design agent, or a person in the sole and regular employment of the principal in writing to the registrar in the prescribed manner. These are the category of persons are eligible to apply for registration of the layout design. Then the application can be filed either alone or jointly. The application has to be filed within the territorial limits, that is a principal place of business in India of the applicant, where the person carrying a business, uh, that is a principal business, in that place he has a right to file an application. Then what is the procedure for registration? Filing of application and writing to the registrar in the office of the SICLD registry in a prescribed form, along with the three sets of drawings produced to the plotter which describes the layout design, and three sets of photograph of mask used for the fabrications of the semiconductor integrated circuit by using of the layout design or drawings which describes the pattern of such marks. Acceptance of the application by the authority with acknowledgement by way of returning one copy of the application. The registrar can also withdraw the acceptance if application is found to be prohibited for registration. Then the application is advertised in a prescribed manner within 14 days of the acceptance of layout design. If any opposition is found to the registration, then the notice is sent to the registrar in the prescribed manner within 3 months from the date of advertisement. The registrar can call for evidence to be produced by both the parties and finally give his decision. If the application is not opposed or the opposition has been decided in favor of the applicant, then the registrar shall register the said layout design in the register of layout design and also issue a certificate sealed with the seal of the SICLD registry. Then once the layout design is registered under the Act, what is the duration of protection available? Here, the registration of the layout design shall be only for the period of 10 years counted from the date of filing an application for registration or from the date of first commercial exploitation anywhere in any country wherever is whichever is earlier. Sorry, whichever is earlier. So that means once the integrated circuit or a layout design is registered, then it will be protected for 10 years. Exclusive right to the registered proprietor, then registration of the layout design gives to the registered proprietor of the layout design the exclusive right to use of the layout designs and also to obtain relief in respect of the infringement. This right shall be available to the registered proprietor of that layout design, irrespective of the fact as to whether layout design is incorporated in an article or not. Then a person may be registered as a registered user of the layout design when the registered proprietor and the proposed registered user apply jointly in writing to the registrar. So, is there any assignment and transmission of the registered layout design? Yes, a person who becomes entitled by the assignment or a transmission to a registered layout design shall apply to the registrar in the prescribed manner to register title. The registrar on the proof of his title to his satisfaction register him as the proprietor of the layout design. Because here it is a transferable one, so a registered layout design is a transferable. You can transmit the layout, registered layout design to some other persons. A protection against the infringement, the act of reproducing, selling, importing, or distributing of integrated circuit layout design for commercial purposes constitute a infringement where such act is performed for the purpose of scientific evaluation, analysis, research, or teaching shall not constitute the act of infringement. Of course, where where a person unauthorizedly use the integrated circuit layout design for the commercial purposes, definitely it constitute an act of infringement where an individual make use of the registered integrated circuit layout design for only importing a knowledge so to the pupil or in order to conduct further research or for the scientific evaluation, it is not amounts to an infringement. So there is no any act of infringement. Any person who commits infringement shall be punishable with the imprisonment for a term which may extend to 3 years or with fine which shall not be less than 50,000 rupees but which may extend to 10 lakh rupees or with both. So then it has created an adjudicatory body. The Government of India appoints a person to be known as a registrar of the SICLD. He has both administrative and legal powers. Any person aggrieved by an order or a decision of the registrar may file an appeal to the Layout Design Appellate Board. Layout Design Appellate Board. The procedure and the powers of the appellate board are the civil code that of the civil code has given under the civil procedure code 1908. If any person is not satisfied by any decision or order of the appellate board may file appeal to the high court within the prescribed period and in prescribed manner. So here, these are the some of the highlights of this legislation. There is a protection of semiconductor integrated circuit layout and designs by a registration process. There is a mechanism for distinguishing which layout designs can be protected. There are rules to prohibit registration of layout designs which are not original and which have been commercially exploited. Because already layout designs are commercially exploited, then there is no question of protecting such layout designs under the Act. Then the protection of 10 years period is provided to layout designs. Provisions regarding infringement and evidence of validity are mentioned. There are a provision for determining payment of royalty for registered layout designs in case of innocent or unintentional infringement. Then penalty in the form of imprisonment and fine are imposed for willful infringement or other offences in the Act. Registrar is appointed for the purpose of administration and appellate board is established for facilitating the legal objective. So this is about the Protection of Semiconductors Integrated Circuit Layout Designs Act. Let us move on to the one more area, that is MRTP Act 1969 or Competition Act 2002. So here, in India, the monopolies and restrictive trade practices were regulated till recently by the Monopolies and Restrictive Trade Practices Act 1969. It is one of the old legislation which regulating the monopolies and restrictive trade practices across the country in the era of 1969 to 2002. However, such MRTP Act has been replaced now by the Competition Act 2002, which had received the assent of President of India on 13 Jan 2003 while certain sections of the Act came into force on June 19, 2003. So here the present Act, Competition Act 2002, which establishes the Competition Commission as a legislation under the Competition Act, which was established on October 14th, 2003, which replaced the MRTP Commission established under the MRTP Act. The Monopolistic and Restrictive Trade Practices Act 1963, it was enacted with the purpose to ensure that the operation of the economic system does not result in the concentration of economic power in hands of few, because there must be a decentralization of the uh, economic power. It should not be concentrated in a group of individuals. So that's what, in order to ensure the operation of the economic system does not result in the concentration of the economic powers in hands of few, this act was enacted, and with the purpose to provide for the control of monopolies, control of the monopolies. I mean, the market should not be monopolized under the hands of few. So that's what here, to, in order to control the monopolies, the Act of 1969 was enacted. Then, with the purpose to prohibit the monopolistic and restrictive trade practices, the MRTP Act extended the whole of India except of Jammu and Kashmir. The MRTP Act sought to prevent the concentration of economic power to the common detriment by preventing those developments which might result in the concentration of economic power, such as substantial expansion of existing undertaking. Then, with the purpose of mergers and amalgamations, takeovers and interconnections of the some undertakings. MRTP Act was significantly amended in the year of 1982, 1984, 1985, and 1991. The amendment of 1985 was to raise the asset threshold of undertaking from 20 crores to the 100 crores for applying the provisions of MRTP Act relating to the prevention of concentration of economic power. So year after a few years, in the year of 1991, there was a lot of changes in the national economic policies. The industrial policy statement of July 24, 1991, which announces a very drastic changes in the MRDP Act. One is repeal of provisions of Act pertaining to concentrating of economic power, that is investment limits, except the provisions empowering the government to diffuse concentration of economic power to the common detriment. Then the provisions of the MRTP Act pertaining to the concentration of economic power were much criticized because of their negative impact on the growth and competition. What do you mean by monopolistic trade practices? Here, a monopolistic trade practice is a trade practice which has or is likely to have the effect of reasonably preventing or lessening competition in the production, supply, or distribution of any goods and services, limiting technical development and capital investment to the common detriment, or allowing the quality of goods and services to deteriorate. So that is called as a monopolistic trade practice. And monopoly trade practice shall be deemed to be prejudicial to the public interest. If having regard to the economic conditions prevailing in the country and to all other matters which are relevant in the particular circumstances, the effect of the trade practices are would be to increase unreasonably the cost relating to the production, supply, or distributions of goods or performance of any services, to increase unreasonably the price at which goods are sold, then the profits derived from the production, supply, or distributions of any goods, including their sale or purchase, or from the performance of any service, then to reduce or limit unreasonably competition in the production, supply, or distribution of any goods or the provisions of any service, then to limit or prevent uh, unreasonably the supply of goods to the consumers or the provisions of any service, then to result in a deterioration in the quality of any goods or in performance of any service. Then restrictive trade practice. It is a trade practice which has the effect, actual or probable, of restricting, lessening, or destroying competition. Destroying competition. It is an antithesis to the monopolistic trade practices. Such trade practices may tend to obstruct the flow of productions or bring about manipulations of prices or conditions of delivery, etc., to the common detriment. The distinction between two is based perhaps on the Monopolies Inquiry Commission, which is confined the word restrictive trade practices to mean restrictive trade practice other than those pursued by monopolists. Monopolist. Unfair trade practice. An unfair trade practice means a trade practice which, for the purpose of promoting any sale, use, or supply of any goods or services, adopt unfair method or unfair or deceptive practice is called as unfair trade practices. Unfair trade practice may be categorized into a false representation by an individual, bargain price, offering of gifts and prizes. It is another practice of unfair. Then non-compliance of prescribed standards, non-compliance of prescribed standard. It is another category of unfair practices. Then hoarding or destruction of goods, hoarding or destruction of the goods. These are the categories of unfair trade practices. That is false representation, bargain price, offering of gifts and prizes, non-compliance of prescribed standard, hoarding or destruction of the goods. So, apart from these, the old MRTP Act was replaced by the Competition Act of 2002. The Competition Act 2002 is a law that aims to protect the interest of the customers from anti-competitive behavior, encourage and maintain market competition, defend consumer rights, and ensure the freedom of trade of other market players. That is the very rationale behind the enactment of Competition Act 2002. Here, this Competition Act 2002 provides the Competition Appellate Tribunal, the Competition Commission of India, and the National Competitive Policy are the three primary parts of the competition law upon which the Competition Act was construed. This regulation is passed typically to make sure the market competition features as supposed and that purchasers can get access to a much broader variety of goods at honest cost. So when we see the features of the Competition Act 2002, which replaced the MRTP Act, it defines the various terminologies like anti-agreements. No person or business may participate in production, supply, or distribution activities that would have a detrimental effect on India's competitive environment. Such agreements are considered illegal in any form. So, anti-agreements are nobody should involving in a competitive environment. So definitely that is protected under the Act of 2002. That is anti-agreements. Abuse of dominating position. If a business or a connected person is discovered to have engaged in unfair or discriminatory actions, this is seen as an abuse of dominant position under the Competition Act 2002. A party will be the subject of an inquiry by the relevant authorities if it is discovered that they have abused their position. And according to the Act, a combination is a set of conditions that result in a mergers and acquisition. The Competition Commission of India would examine the parties concerned if such combinations exceeded the restrictions set forth by the Competition Act 2002. Then Competition Commission of India is a statutory body which created under the Competition Act 2002. It is an independent organization and has authority to enter into contracts and if such contracts are broken to bring a legal action against the violators. The commission, which has a maximum of 6 members, is in the charge of upholding and advancing consumer interest to establish the optimum conditions for economic competitions. Under the Competition Act 2002, the Commission other responsibility is to provide advice to the Indian government on matters related to economic competitions and to raise public awareness of the problem. Friends, let us discuss the Competition Commission of India, which is established under the Act. The Competition Act 2002 throughout India and to prevent activities that have an adverse effect on the competition in India, Competition Commission was established, which is a body of the government of India, which is responsible for enforcing the or implementing the Competition Act 2002. Objectives of the Competition Act 2002. It was established on 14th October 2003. It became fully functional in May 2009 in India. When we see the composition of the Competition Commission, that is, a commission comprises chairperson and not less than two and more than six members appointed by the central government. The chairperson and every other member shall be person of ability, integrity, and standing, and who has a special knowledge of and such professional experience of not less than 15 years in international trade, economics, business, commerce, law, finance, accountability, management, industry, public affairs, or competition matters, including the competition law and policy, which is in the opinion of the central government may be useful to the commission. Then what are the duties of the sorry, what are the duties of the commission? Competition Commission. One of the duty is that to eliminate practices having adverse effect on competition. It is the main duty cast upon the Competition Commission. So there must be elimination of practices which is adversely affecting the competition. Then to promote and sustain competition. To promote and sustain competition. Then to protect the interest of consumers and ensure freedom of trade in the markets of India, to encourage creation of entities which can deliver faster and better goods and services. It is another duty cast upon the commission. Then the commission is also required to give opinion on competition issues on a reference received from the statutory authority established under the any law, then to undertake competition advocacy, create public awareness, and impart training on competition law. Import, training and competition law. These are the duties cast upon the Competition Commission of India. Then the powers given to the Competition Commission, they shall have commission shall have the powers to regulate its own procedure. The commission may call upon experts from the field of economics, commerce, accountancy, international trade, or from any other discipline as it deems necessary to assist the body in conduct of an inquiry it undertakes. Then the Competition Amendment Act 2007 was enacted to amend the Competition Act 2002. This led to the establishment of the CCI and the Competition Appellate Tribunal. The Competition Appellate Tribunal has been established by the central government to hear and dispose of appeals against any direction issued or decision made or under order passed by the CCI. The Competition Appellate Tribunal with the National Company Law Appellate Tribunal in the year of 2017. Friends, another area is called Office of the Controller General of Patents and Designs. Office of the Controller General of Patents and Designs and Trademarks. Office of the Controller General of Patent Designs and Trademarks is a subordinate office of the Department of Industrial Policy and Promotion. The Office of the CGPDTM administers administers the following acts. One is Patent Act 1970, Designs Act 2000, Trademarks Act 1989, Geographical Indications of Goods Registration and Protection Act 1999. These are the four enactments comes under the Office of the Controller General of Patents, Designs and Trademarks Act. This CGPT TM directs and supervises the certain offices. One is patent office, including the designs wing. Patent Information System, Trademarks Registry, Geographical Indication Registry. It is supervised by the Controller General of Patent, Designs and Trademarks. So here we need to discuss about the patent office. The head office of the patent is in Kolkata. The regional offices having a territorial jurisdiction on zonal basis are Mumbai, Delhi, Chennai. Addresses of these offices along with their jurisdictions are given in the Appendix A of the Act. The trademarks registry is at Mumbai and the geographical indication registry at Chennai. So if you want to register any goods under the GI tag, then you have to approach the Chennai office. Then if you want to register any mark as a trademark for your goods, then you have to approach the Mumbai office. Computerized information is available about status of patent applications, receipt for filing of patent applications, etc. Digitalization is made, including scanning of records of patents and designs has been done. A website gives updated information. Patent office brings out an official journal under the name of the Patent Official Office Journal. Then the Patent Office also handles international application. International applications filed under the Patent Cooperation Treaty designating India. It also provided for filing of the product patent applications related to the pharmaceutical and agrochemicals in the mailbox prior to John 1st, 2005, and has established a system for grant of executive exclusive marketing rights as required under the TRIPS agreement. Under the modernization of patent offices, email connectivity has been established between the offices. Online search facilities have been provided, and ISDN facility has been provided to the offices to ensure the uninterrupted connectivity. Then there is a trademark registry which is under the supervision of the control of the trademark. Head office of the registry is located at Mumbai. Four branch offices are located at Kolkata, Chennai, New Delhi, and Ahmedabad. They have their own territorial jurisdiction. The Control General of Patents, Designs, and Trademarks is the registrar of the trademark. Applications for registration, renewal, or cancellation of trademarks are received at the trademarks registry where they are processed. The trademark registry performs statutory functions as laid down in the Trademarks Act 1999. The register of trademarks contains the record of all registered trademarks with names, addresses, and description of the proprietors, users, assignments, and transmission conditions, and the limitations and the particular of registered users. A digital library of more than 150,000 trademarks and 1,250 trademark journals and CD-ROMs has been created. One more registry called Geographical Indication Registry. Geographical Indication Registry. And as envisaged in the Geographical Indications of Goods Registration and Protection Act 1999, a geographical indications registry located at Chennai, it has come into existence uh, as per the Act of 1999. The Controller General of Patents, Designs and Trademarks is the registrar of the geographical indication. The registry is responsible for the registration and protection of GI and performing statutory functions as mandated by the Act 1989. The register of the GI contains a record of all materials, particulars in respect of the registered GI and the authorized users. Friends, these are the registries comes under the patent office, trademark registry, geographical registry, which are regulated by the different legislations. Comes under the supervisions of the Control General of Patents, Designs, and Trademarks. So these are the things about the two blocks, that is the protection of other industrial property and operational aspects of the protecting of IP in India. Yes, I'm going to wind up the session. If you have any doubt, please.
Sir, I'm not sure the lecture is based on which course, 105 or 104?
Yeah, it is based on the 005, MP 005, madam.
Okay.
In MP 005, there is five units, no?
No, sir. 105 is a copyright.
No, no, no. Here in block 3 and 4,
Yes, sir. But in that notification, they mentioned that
see,
M.
block 3 and 4. Yesterday I did block 1 and 2 in MP 005, that is protection of industrial properties at the national level, patent protections and the protection of designs and trademarks. Other industrial properties like in your unit 7, which talks about GI, geographical indications, and unit 8 talks about the biodiversity and the Indian law. Then unit 9 talks about that is protection of plant varieties and farmers and breeders' rights in India. Then unit 10 talks about protection of semiconductors, integrated circuit layout designs.
Okay, sir.
Then
Sir,
black
your
4
explaining, sir.
talks about unit 11, MRTP and Competition Act. Then
Thank you.
unit 12, that is about protection of IPR in other countries. Like unit 13 talks about Office of the Controller General of Patents and Designs.
Okay, sir. You are overall covering all the units.
Yeah, yeah.
Sir, your explanation is very good, sir. It was convenient, but that slide is not moving, sir.
I'll
Finally,
share the slides with madam. Madam, please. Huh?
okay, sir. Okay, sir.
Okay.
You will get it from the IGNOU Center, sir.
Yeah, you can collect from the madam.
Oh, thank you.